So far, we've spent quite a lot of time thinking about what happens before a development is undertaken. This changes tack a little bit, and we talk about enforcement under the Land Use Planning and Appeals Act. So, what happens when people develop and they haven't applied for a permit, or the development goes outside the permit? So, I'd like to thank Kirsten Turner, who's the Manager of Development Compliance at the City of Hobart, very much for the material that's supplied here. Kirsten is in charge of 15 staff at the City of Hobart, and they look after all compliance in building, plumbing and planning at the council. Her background is that she has an economics law degree, she has a Master's of Environmental Planning from the University of Tasmania, and she has a Master's of Environmental Law from Macquarie. She has been in private practice as well as now having very extensive council experience. So she has, along with her staff, responsibility for all the compliance actions and enforcement of all the bylaws. She's responsible, and the team are responsible for all the signs that go up for the development applications around Hobart. She's also responsible for animal control. So compliance officers work in this section to investigate complaints. So what I'm about to go over is material that Kirsten presented in class, and yeah, thank you very much for your involvement. It's been fantastic. Here's what we're going to be covering in plain language before we start getting into different sections of the Land Use Planning and Approvals Act. So generally, enforcement means that you ensure compliance with the law, that you prevent threatened breaches as well as existing breaches. So a threatened breach could be needing to respond to somebody who says, look, there's somebody with some tree lopping equipment down in the park, or on a piece of land that they think doesn't have a planning permit for any removal of trees, and it's council's obligation to go and investigate that. Enforcement includes punishing breaches of the planning scheme permit conditions. Enforcement means that officers have a duty to ensure development or use that requires approval doesn't occur without approval. So if you're proposing something that requires a permit and you don't have one, then that's where enforcement needs to step in. Determine applications in accordance with the terms of the planning scheme and ensure that developers comply. So there's a range of things around permits and permit conditions and doing things within a time and in accordance with your permit conditions, and also anything that falls outside the permit process. So you might be doing something that you don't have a permit for. So there's a few different sections under Lupa, and this is in the unit manual. So sections 48, 63 and 64, that's not listed on this slide. So a key thing to remember is that planners working a local government environment need to be aware of these parts of Lupa, and that they have a legal responsibility to investigate complaints. So 63 sets up provision for what people need to do, and 63A is about council failing to enforce its planning schemes. The council itself can get into trouble if it doesn't act. So even though this is something that doesn't happen very often, and in fact there's really only the one example that I'll talk about in a minute, it is a big threat. So councils do take their obligations to enforce their planning schemes very seriously. I skipped the top one. Section 48 relates to the planning authority needing to enforce observance of the planning scheme. And I'll get into all these details with some cut and paste sections from the manual in a minute. So this is something that both has been emphasised in the manual. So this is bold out of the manual, cut and paste out of the manual, and something that Kirsten emphasised in person. If you're working for local government and you believe somebody has committed offence, you really need to act very quickly, particularly if it looks like the offence is imminent, so somebody's near a tree with a chainsaw, somebody's on site with an excavator, then you need to act really quickly. And a failure to give bodies or persons enough time to investigate or commence proceedings may result in no prosecution capable of being brought. So in order to have people take the planning scheme seriously, then the threat needs to be real, which means people need to act on information and act quickly. So this is a cut and paste from the relevant section of the unit manual under the introductory material about enforcement. So the first category of 3 categories of about enforcement deal with this first section, section 48 of the Land Use Planning Appeals Act. So it establishes a legal obligation on planning authorities to observe and enforce planning scheme which regulates the activity within their local government area, section 48, and to enforce any condition or restriction under a special permit. So that's a particular part of section 48. And this is what the legislation actually says. So under section 48, where a planning scheme is enforced, a planning authority must act. 48AA, enforcement of special permits. A planning authority must, within the ambit of its power, enforce the observance of any condition or restriction to which a special permit is subject. Section 63A, again, this is a cut and paste from the manual, so you don't necessarily have to go back and read it, although it's probably a good idea. Section 63A makes it an offence for the planning authority not to take all reasonable steps to ensure compliance. And there's some extra material that Jarrod's included in the manual about how this takes place. And there's penalties in breach of this obligation. The actual legislation looks like this. A person must not use land in a way or do any other act that's in contrary to a state policy or planning scheme, remembering that state policies get written into planning schemes, impedes the execution of such scheme, constitutes a breach of a condition. You get the gist. While council's kept really busy by people calling in to complain about possible breaches, there are very few cases of prosecution of the actual council in their role as a planning authority under 63A. The one case was Hobart City Council deciding not to act in the case of a neighbour complaining about car parking when there was building work being conducted at Calvary Hospital. And so this ended up going to the Magistrates Court, Hobart City Council v Ellis, and eventually onto the Supreme Court. So that's what that TAS Supreme Court 71 refers to, is that it eventually ended up in the higher court. So in Ellis v Hobart City Council and the Magistrates Court, the neighbours complaining that the Hobart City Council needed to act on this breach. It was a really clear breach. But interestingly enough, when it got to the Magistrates Court, the magistrate noted that it wasn't necessarily unreasonable. So I'm reading from the second set of text here. It wasn't unnecessarily reasonable for a council to refuse to prosecute a developer for the breach of a scheme. So even though it ends up in court, prosecution is a penalty, and the court can decide that they're not actually going to impose that penalty. Prosecutions are discretionary, as it says here, the decision to prosecute being made in the public interest. Prosecution leads to the imposition of a penalty rather than an order to stop or make good a breach. So to rebuild or redo, you're just being given a penalty. So it doesn't necessarily succeed in enforcing the scheme. So in this case, the magistrate decided, once it had heard all the evidence, it turned out that the reason why the council didn't act is because it was just easier and less inconvenience for the neighbours to not do anything about the breach, just let them get on with it. Let them use the parking that the neighbours didn't like, because anything else was going to actually make it worse for the neighbours. And the magistrate agreed with them. Then Ellis went further to the Supreme Court. The magistrate's court decision was subject to appeal to the Supreme Court, and the Supreme Court found for Ellis. So it found that council should have actually done something about the breach. There you go. Unusual, you won't have to worry about it, but it is in the legislation it's provided for. Section 64 of the Act deals with civil enforcement. Civil enforcement is a legal action that anybody can take. So if you want to allege that somebody has breached Land Use Planning and Approvals Act, and that might be you think that they haven't got a planning permit, or that they have got a planning permit, but from your knowledge of the development, it looks like they're going outside the conditions of that permit, this is where you can bring civil enforcement proceedings. So you can initiate by letting council know that something a bit sus is happening. So this is not what you do when you want to complain about council's decision-making process or mistakes that council have made. This is about something that where a development doesn't have approval or doesn't comply with conditions. So this is from the manual, Civil Enforcement under Section 64 of Lupa. This has changed over recent years. So an application under Section 64 can only be brought by an individual who isn't a council authority and isn't the Planning Commission. So this is something that councils used to use quite a bit, and now they need to use other parts of Lupa. So this changed. I've got it somewhere. Next slide. So this is all from the manual. The important parts of Section 64 is that you need to act pretty quickly. So there is limited time within which to make an application after the date of a breach. So get onto it as quickly as possible so that the evidence needs to be collected. In terms of temporary orders, which is also called interlocutory orders, can be sought to preserve the status quo and stop somebody from doing something, preventing further harm. And Section 64 also deals with the discretion of the tribunal as to whether any orders of a breach are actually followed up on. So again, this goes back to the same Calvary example, Hobart City Council versus Ellis. So when it did end up in the magistrate's court, just because there was a breach doesn't mean to say that the magistrate's court was going to follow through. So what they're looking for is the appropriate outcome that will uphold the planning system. And so it depends on the nature of the breach and on the punishment follows. So it doesn't necessarily mean that the person might be prosecuted for breaching the act. So it's up to the court to decide what's appropriate. But this is all part of Section 64. So here's what we've got, the changed enforcement provisions for councils. So Section 65A through M were introduced into the Act in 2015. They contain enforcement provisions that are designed to provide councils with, quote, a more effective response and less expensive system of enforcement procedures, and provide an improved and more cost-effective tools which make it easier to enforce planning schemes and permit conditions. My impression is that councils do miss their powers under Section 64. It might be worth, and this is something that I haven't mentioned so far in this unit, going back to actually the second reading of the speech where a bill is before Parliament can be really instructive, because that's where all of the arguments have put forward as to why the bill should become legislation. So that footnote there, under 70, on the 17th of October in 2013, there was the second reading of the relevant part of the changes to the Land Use Planning Approvals Bill. That can be interesting reading because it's a mix of the rationale, there might be comment on the politics, and so it's something to bear in mind in terms of going back and being thorough about finding sense in legislation, is going to those second reading speeches. So now councils have section 65A, which gives them the power to issue infringement notices for a specific offence. So this is a tool that's very commonly used now. And section 65B through E set out the procedure for the issue of the notice of intention to issue an enforcement order, and just hold that thought because there's some examples coming up. The next parts of that section, F and G, provide for the procedure for cancelling a permit. I'm not going to spend time on this because this happens very rarely. So the planning authority, these are new powers under that change legislation that came in 2015. And yeah, this is a big deal. If a council, a planning authority, is going to cancel a permit, there could be all sorts of ramifications, so it's not actually being used yet. So this is another cut and paste from the manual and just highlights some of the general rules about enforcement processes and where people get into trouble. So 6 dot points. The one area is the delegation of power to issue or commence. The second one is about needing evidence. So you need a proper basis of evidence for enforcement. So even though you might suspect that something's amiss, until you've got evidence, the council, the authority, really isn't able to proceed. So people who work in enforcement need to be really thorough and need to be often a bit, creative's the wrong word, but need to be persistent in terms of following up and making sure that there's a proper basis of evidence. Need to make sure that there's no procedural errors in the way that things are done under Lupa. Things need to be certain. So again, this goes back to some of the earlier points in the manual about natural justice, about things needing to be clear and final, permit conditions needing to be well worded. They need to be reasonable. Then there can't be an abusive process, and this is where the actual planning needs to be kept separate from politics. So a short recap of section 64 that was amended in 2015. That means that civil enforcement application is only available to people other than the Planning Authority and the Tasmanian Planning Commission, and it may only be sought within 120 days after an application to a Planning Authority, so that's where the time limit comes in. So the powers under this amended Lupa are infringement notices, an enforcement notice, cancellation of a permit, which, as I've said, doesn't happen very often. Authorised officers are important. They have quite wide-ranging powers, more powers than actually the police do in terms of being able to go on land and investigate something. So this is, again, under those later parts of section 65, and an authorised officer under Lupa has the ability to go on land, to ask for copies of correspondence, and any attempt to obstruct that authorised officer is itself an offence under 65M. So no assault, well, yeah, I guess you need to spell that out, but hopefully that should be fairly obvious. You can't obstruct them or impede them, you can't mislead them, you can't resist, and you can't impersonate an authorised officer. You can't turn up and pretend that you're from council. That also is covered under 65M. This is good news. This also happens under EMCA, the Environmental Protection and Pollution Control Act. Authorised officers have wide-ranging powers that are stronger than police to go onto land and investigate. An infringement notice comes under 65A and it's issued by the authorised officer. It is one of the options that can be used for an offence. So it might be that council, and we'll talk about this when we come to 55 Mount Stewart Road, might choose to do something other than issue an infringement notice. What it's designed to do is be punitive. It's a punishment. So council might decide that either an infringement notice is an inadequate punishment and they go through the courts instead of issuing an infringement notice, or depending on the case, they might want to take a different course of action. So this is an imposition of a fine, a monetary penalty that's punishment for a breach. This is what an infringement notice looks like. I realise the text is quite small, but it's just readable. So you can see at the top there under the title, this is issued under section 65A, and there are the details of the offence that go along with the notice there. So this was about undertaking a development breach of, I can't quite read that. You might be able to read that if you're on a bigger screen, but that's what an infringement notice looks like. Enforcement notices come under sections 65B through E. They're issued by an authorised officer, and they're for an offence or likely offence under these different sections of Lupa. The authorised officer needs to put out a notice of intention to issue an enforcement notice. This is different language compared to what building uses, but there you go, that's what it is. And it's an offence not to comply with an enforcement notice. So an authorised officer might issue an enforcement notice to remedy, stop or prevent an offence. They issue something that looks like this. This is the notice of intent, and it just has the actual offence and the particulars of the offence, and it doesn't say what needs to be done to rectify the situation. So at least in terms of the City of Hobart, they issue a cover letter that goes with this notice of intent that informs the recipient of what they have to do, that what would come in the subsequent enforcement notice. So the enforcement notice that follows up the notice of intent would look like this, and it would have the description of the offence. This is on the first page. On the second page is the requirement of the notice with what you are required to do. You are required to, within 21 days of this order, to remove the signage. In this particular case, was about signage that was going up in the service industry for which it required a permit and didn't have the permit. So either remove the signage, B, obtain a permit and cease putting the sign up until you've got permission to do this, or obtain a permit for the change of use in accordance with the requirements of HIPS. So this really clearly spells out what needs to be done, but as good practice, Hobart City Council let people know in the notice of intent as well. I'm going to be very brief on this. This is sections 65F and G. Cancelling permits. This has not happened so far. Admittedly, this particular power hasn't been in place for very long, but Kirsten said this is something that would have very serious ramifications. If there had actually been development and then the permit is cancelled, there could be all sorts of serious consequences of that, so it's not been used. And again, you give a notice of intent to cancel a permit before you issue the cancellation. Now to get around to talking about 55 Mount Stewart Road. So there were a few possibilities here. I guess to backtrack immediately. So what happened on that Sunday is that council were alerted to the fact that there was somebody on site with equipment to take down the trees, and there was a discussion and it was made clear to the people on site that no work was to go on, that they didn't have a permit. There might have already been some damage to the trees, a bit hazy on the details, and then the authorised officer left the site thinking that it had all been cleared up. What then happened is that an excavator came on site and did the damage that you're looking at here. So this was a really blatant breach of the Land Use Planning Approvals Act, and a whole lot of other problems as well, problems under the Building Act, problems under MCA around asbestos and doing material harm, a real mess. In terms of council's actions, they could have issued infringement notices, but the penalties, as you might have been able to see in the small text, although they've increased in recent years to council being able to impose penalties of a few $1,000s, in this case, the offences of 2 trees, that adds up to an offence. There's the offence for actually bulldozing the heritage listed building as well as the heritage listed trees. I think Kirsten said that there were 4 offences in total. So even if you issued infringement notices for 4 offences, that's a really trivial slap on the wrist. So this is going to court, and council are seeking maximum penalties. I'm not sure of the details. I don't know that they're public yet, apart from the fact that council is going to court about whether the land will, in quotes, be sterilised for 10 years, or whether they're seeking just to punish the owner in terms of actual financial penalties. But council are definitely going after penalties for these breaches, and we'll just wait and see what happens in terms of what plays out in court. So this has been a really unfortunate incident, but one that's been interesting timing in terms of our learning in this unit. So that's all that we covered in terms of enforcement. So I hope this has been helpful. You might like to read through the relevant section, the last section of the manual on enforcement. Quite a lot of the manual I've cut and pasted in terms of the purposes of talking through this today. And yeah, hopefully you've got a good sense of what's possible and what the most well-used parts of Lupa are, and which are the bits where there's provision in legislation for council powers to do something, but they tend not to be used. They're not very useful. Okay, thank you.